Alright guys, welcome back to another edition of Lawyered Up. I am your host Jared Moore, and as usual, I'm not a lawyer, but we are going to try to figure out what's going on with all these lawyers. And today we have an update to prior coverage, which is in the description of this video, and it is the case at the MCN Supreme Court about the constitutionality of NCA 24-077. So without further ado, let's jump right in. I'm going to take me off of here. If you guys have any questions, pop them in the chat. I will try to answer them. But at this stage, we are looking at the Creek Supreme Court's website. We're going to go to opinions. I'm going to try to go to opinions. Well, maybe I'm not going to go to opinions. Current docket, yes. Okay, there we go. I got scared for a second. All right, so we have the case we're looking at, and then we're going to look at the order and opinion here. There's a link to all of this information in the description, or you guys can go to the Mvskoke Creek Nation Supreme Court's website and check it out there. What we're looking at here is the order and opinion about the constitutionality. I wanted to just point out a couple of things that I found interesting, but I do encourage you guys to read the entire opinion. But the first thing I wanted to take a look at is on page 11. I believe it's 11. Let me go skip ahead here. Sorry. Here we go. This is what I'm looking for. And I'm starting here. Let me see if I can highlight this. Yes. This is where I'm starting. To begin, the court finds it necessary to briefly reiterate the concerns it expressed with this process in its February 21st, 2025 oral argument. Unlike the nomination and confirmation process for an Article 7 justice, where the confirmed justice will serve a 6-year term with the option, absent recusal, to hear all cases there filed to the court, the nomination of a special justice is for a singular case. This places an inordinate amount of power and influence with the legislative and executive branches of government, where the circumstances are ripe for a special justice to be selected based entirely on a desired outcome for the specific case. Even if the motivations of the legislative and executive branches of government are well-meaning, the decision by the other branches to meddle with the nation's past precedent creates an appearance of impropriety. This court has a duty to protect the integrity of the nation's judicial system. This court has previously explained that, quote, "It is the responsibility of the judge in all cases to determine himself, using his best judgment, if his decisions will be perceived as unfair, requiring recusal," end quote. Further, that, quote, "In deciding whether a decision will be perceived as unfair, a judicial officer should consider the case from both a subjective standpoint, assessing whether the judicial officer considers himself or herself to be impartial, and an objective standpoint, asking whether the public would reasonably consider the judicial officer to be impartial." In this instance, the court views the following circumstances as objectively problematic. 1. The executive and legislative branches of government are involved as parties in SC 2023-10 and are solely responsible under NCA 24-077 for selecting the special justices to hear their case. 2. The legislative and executive branches of government argued in briefing and during oral argument that a quorum issue has existed since this court's decision in Ellis, SC 2010-01, a decision issued on May 2, 2013. Yet nothing was done to address this, quote, problem, end quote, until the eve of the oral argument in SC 2023-10 in June of 2024, over 10 years later. Passing NCA 24-077 via an emergency session shortly before oral argument. Finally, 3. Both NCA 24-077 and the tribal resolutions nominating and confirming the special justices were all passed and signed on the same day, further evidencing that SC 2023-10 was the specific target of NCA 24-077 as opposed to a general desire to address concerns arguably created by the Ellis decision. Due in large part to these circumstances, there is a great public perception that NCA 24-077 and the tribal resolutions appointing the two special, justices were enacted to produce a desired result, whether or not that perception is correct. In reality, this perception would be the case in any matter, present or in the future, in which the legislative or executive branch is a party to the action before this court. It defies reality to believe opposing parties, the public, or foreign jurisdictions would not suspect wrongdoing when a party in an appellate matter is given the ability to unilaterally select the judicial officer hearing their case. Under this court's case law precedent mentioned above, such a perception would be enough to justify recusal of the newly appointed special justice from the outset, creating an endless loop in which every special justice appointee would be expected to recuse as soon as they assumed the case. Okay, so that's the first thing that I would like to point out there, is that the decision is kind of saying if we allow a special justice to be appointed, that their bias is going to be questioned every time that happens, and then they'll have to recuse. We'll just be in an endless loop. The next thing I wanted to point out is on page 13, and it is it addresses some of the concerns that we talked about in the oral arguments recap about habeas corpus. So I'm going to read you that part. Finally, the court has expressed its concern that NCA 24-077 specifically applies to writ of habeas corpus actions. Under the court's appellate rules of procedure, an appellate seeking a writ of habeas corpus is guaranteed to have their actions set for hearing within 72 hours of filing, with at least a 3-justice panel. NCA 24-077 upends this appellate rule, requiring a full complement of 7 justices to hear the writ, and giving the executive and legislative branches up to 90 days to finalize their selection for any recused justice's seat. Writs of habeas corpus are particularly important actions, as no man or woman should be unjustifiably detained by the nation. To require an appellate in a writ action to wait up to 90 days in jail while the nation scrambles to fill recuses justices' seats is simply unacceptable. All right, so those are the two most interesting things that I found in there. Again, I recommend that you guys go ahead and read the whole thing if you're interested in this topic, and I'm going to go down and read the conclusion. For the reasons stated above, the court finds NCA 24-077 unconstitutional and unenforceable. Further, as a result of this finding, the court finds TR 24-073, appointment of James Jennings, and TR 24-074, appointment of Samuel Deere, unconstitutional and unenforceable. Finally, the court finds that the appointment of a special justice pursuant to NCA 24-077 and any other pending Supreme Court action is likewise unconstitutional and unenforceable, and that with the issuance of this order and opinion, any stay of proceedings filed in any other Supreme Court action for the purpose of resolving the constitutional challenge related to NCA 24-077 is hereby removed. So what are they talking about there? Let me back up a page. You guys might remember from previous coverage that this constitutionality case was filed in relation to MCN Citizenship Board versus Rhonda Grayson. And so we're going to go back and find that is on the current docket. You'll see it's right here at the top. And that case had been stayed right here. Sorry, 1 second. That case had been stayed pending the decision in this constitutionality case, and now that they've made the decision, the next thing we should see happen is an order in the Grayson case scheduling oral arguments. And as soon as that happens or it's posted, I will let you guys know, and we'll be trying to cover those. If you remember what happened with the oral arguments in the constitutionality case, they only live streamed them to their Facebook, and I watched them, and then afterwards I did a live stream where I told what I saw from my notes, and that's probably what we're going to have to do again. I would hope, and I would like if the court would stream it to Facebook and just leave it up. I don't think there's really a reason to take down oral arguments, at least the audio or something, so people could go and watch the oral arguments. Nobody wants to have to listen to me recount the oral arguments. That's boring. But I'll do it if that's the only way we could do it, and that will be determined by the order that the court puts out. So if the court puts out an order and says, we're going to just live stream it, it's only going to be up till the end of the business day like what they did before, we'll do our deal and we'll go down that road, and everything will be hunky-dory. I'm going to back up here. Oh, I did want to mention here at the end, because we had a question on Facebook about the tax case, the Strobel case that's at the Oklahoma Supreme Court, and whether there had been a decision. There has not been a decision in that case, and yes, it has been over a year, and no, I don't know why there hasn't been a decision, because from my perspective, I think it's just a clear-cut case of procedural, the tax commission's own administrative law judge said that she doesn't owe taxes. So we'll see what happens, but no, we don't have a decision there, and I'll keep you guys updated with any new developments as soon as they happen, and we'll see you guys next time. Mado, hadum, chihichat, please.